Biden.
Will the gentleman
And with
yield?
that, I will yield the balance of my time to my ranking member.
Ms. Brown, thank you so much. You know, you started off by saying something pretty profound, which is we are here instead of doing the business of the American people because the Republicans have offered us no positive agenda in their year in office. We know we've wasted countless weeks in them just trying to pick a speaker. And we've wasted countless weeks with their inertia and their do-nothing policies. But Ms. Brown, I don't know if you recall, I just don't want people having to take your word for it. I think numerous Republicans have gotten up on the floor of the House complaining about the fact that they have no agenda. I think our colleague Chip Roy from Texas said that the Republicans have not given him one thing, a single thing, I remember him saying, to campaign on. So I just want to ask you, when you're saying that they have no agenda, that's not a partisan point. You're getting that from Republicans, aren't you?
That is correct.
One of our colleagues said that there was Trump derangement syndrome, and of course, Trump derangement begins with Donald Trump himself. He thinks he has a legal right to assassinate U.S. citizens. He thinks he can grab women by their genitals, although that's not the word that he used. He said that if Joe Biden is reelected president, there will be World War II. He is obviously deranged and disoriented. But the real Trump derangement syndrome that I see is those people who cannot break from Donald Trump after he's proven himself to be completely and totally unworthy of your support. Because I'm looking at talented, gifted people on the other side of the aisle, the ones who have not left Congress in frustration or because they've broken with Donald Trump and clashed with him. But I'm still looking at people who have their wits about them, I think, but you're acting like cult members, like you're sleeping on the basement of a cult, listening to tapes all night, and I beg you to get over your Trump derangement syndrome. Thank you very much for yielding, Ms. Brown.
Chair recognizes Mr. Donalds from Florida for 5 minutes.
Thank you, Mr. Chairman. A couple of things. First, it was said in this hearing, Mr. Chairman, about you specifically, that you repeatedly said you would give Mr. Biden any opportunity, he could choose which one, to come and speak in front of this committee. He could do it by deposition, he could do it by open hearing. It was up to him. The truth of the matter, though, is, members, is that the chairman's words are not binding. Like no other member's words of Congress are really not binding. The binding article.
Point of order. Does the chairman agree with that? Point of order. Does the chairman agree?
Are you going to restore my time?
Point of order. Just point of order.
Okay.
Does the chairman agree that the chairman's words are not binding on the committee?
That's not a point of order. It has nothing to do with the order of this hearing. Thank you. Can I go back to 4 minutes and 34 seconds? That's where I was before I was interrupted by Mr. Raskin.
Yes. Reset the clock.
Thank you. Thank you. What is binding is the actual written document, the written language in the subpoena, because a subpoena from this committee is also signed off on by the clerk of the House. That is the binding document that matters here. That is what governs. That's number one. Number two, that was said in this hearing. It was said that our witnesses said that there was no basis for an impeachment. But remember, members on the Democrat side of the aisle, what was said by Mr. Turley at the time was that there was plenty of evidence for the continuation of an impeachment inquiry. And the purpose of that hearing was the relevance basis for an impeachment inquiry. The House has now voted for an impeachment inquiry. And one of the first things that the House did after the vote of an impeachment inquiry was to subpoena Hunter Biden to appear. Hunter Biden has evaded that subpoena. So flagrantly did he evade it that he decided to show up at the Senate side to give a press conference, and Eric Swalwell, a member of the House, helped him get that time on the Senate side to give a press conference. That's a flagrant violation of a congressional subpoena. Secondarily, he has the gall to show up here when we're actually discussing contempt. And he didn't stay. He was sitting right over there. He's not here now. He said he wants to talk. He could have stayed through the whole proceeding. He chose to leave. That's his business. But he was subpoenaed to come here. Back in December, he chose not to of his own volition. He's in violation of that subpoena, a subpoena that was executed with the signature of the clerk of the House of Representatives. That is the document that is binding. That's what we work off of. Mr. Chairman, I actually want to submit for the record an article from The Hill written by Jonathan Turley, and it is titled Eric Swalwell and the Politics of Contempt.
Without objection, so ordered.
Thank you. I'm glad something got admitted to the record. Last, a couple other points. One quick point I want to make, and this is in reference to the minority's report about this $7.8 million. I want the minority to understand one very important distinction between President Biden and President Trump. President Trump has an international real estate portfolio that he has amassed over decades. I'm quite sure if you go back through all of the hotel receipts before he was president of the United States, that you had foreign dignitaries staying at Trump hotels all across the world.
Will the gentleman yield?
I'm not going to yield, Mr. Raskin. I'm making a point. Because they're actually very nice hotels. They look good. People like staying there. President Trump was not running the Trump Organization when he was president of the United States. To my recollection, Eric Trump, the president's son, was actually running the Trump Organization when President Trump was president of the United States. So if he had a portfolio of hotels and people choose, you know, through Expedia, through Kayak, through Hotels.com, if they choose to go and stay there, how is that the president being in violation of what the emoluments clause? That's what you're citing? Stop. Ladies and gentlemen, America, this is ridiculous. The Biden family has no business. They've never had a business except for politics. And the one thing that the Oversight Committee, in conjunction with the Ways and Means Committee and in conjunction with the Judiciary Committee, has always been able to demonstrate is that they took down foreign nations for millions, 26 million at the latest count, and growing, millions. And there was never any business entity involved except public corruption and a pay-for-play scheme. The House Oversight Committee would like to get to the bottom of this under the impeachment inquiry of the House. We have questions for Hunter Biden. We issued a subpoena for him to answer said questions. He ignored a congressional subpoena as a private citizen. There are many attorneys on the other side of the aisle. If you had one of your clients in your private practice ignore a congressional subpoena as a private citizen, you would advise them not to, because they would be held in contempt, and they would actually be punished by the Department of Justice. So I find it interesting
Will
to
the
see
gentleman
today.
yield so I can
I'm not
respond?
going to yield, Mr. Goldman, because I had a question for you earlier. You didn't want to take my question, so I'm not going to take yours. Thank you. So, in closing, I will say, private citizens, yes, they have a responsibility to answer congressional subpoenas. They do. Hunter Biden had it, and he was flagrant. He decided to give a press conference. So we're going to do this business, and he should be held in contempt by the full House of Representatives. I yield back, Mr. Chairman.
Very good. Chair now recognizes Ms. Norton from Washington, D.C. for 5 minutes.
I yield my 5 minutes to Mr. Raskin.
I'd like to thank the distinguished delegate from the District of Columbia, and I need to correct the record because of several false statements made about the Foreign Emoluments Clause, Article 1, Section 9, Clause 8, although I do appreciate the gentleman from Florida's attempt to at least engage on the matter of substance that was raised so powerfully by Ms. Crockett. Now let's start with this. Article 1, Section 9, Clause 8 says that neither the President nor any member of Congress can receive a present, an emolument, which means a payment, an office or a title from a prince, a king, a foreign government, quote, Mr. Donald, of any kind whatever. Of any kind whatever, without going to Congress first and obtaining the consent of Congress. There's no hotel exception, Mr. Donald, to the Foreign Emoluments Clause. There's no international real estate syndicate exception to the Foreign Emoluments Clause, Mr. Donald. And also, I will take you up on your challenge to see whether the Trump Hotel in Washington, the Trump Hotel in Las Vegas, the Trump Hotel on Fifth Avenue, the Trump Hotel at UN Plaza, the four of the more than 500 businesses that we got documentation for, whether they actually had the same level of business coming from Saudi Arabia, the communist bureaucrats of China, who were the leading spender, as you know, if you've read our report, the United Arab Emirates, Indonesia, India, Egypt, and so on. We will make that comparison about what was done before if you get the chairman to call off the ban on further documents coming from Mazars. So
Have you ever stayed at a Trump hotel, Mr. Raskin?
Excuse no, and I never would stay at a Trump hotel. I've got too much self-respect and concern for hygiene. So, but in any event, Mr. Donald, you're totally wrong about what the Foreign Emoluments Clause stands for. Abraham Lincoln was given 2 elephant tusks by the king of Siam during the Civil War, and he liked them very much. He wanted to keep them, but he went to Congress which is what every other president did before and every president did since, right up until Donald Trump. And he asked whether he could keep the tusks. And Congress, though they loved Honest Abe, said, no, you can't keep them. I mean, John F. Kennedy was offered citizenship by the people of Ireland because they loved him so much, and he refused to take it, saying that even though it didn't violate the letter of the Emoluments Clause, it violated the spirit of the Emoluments Clause. And Donald Trump converted the presidency into an instrument for self-enrichment. He raked in millions of dollars from the most corrupt governments on earth, who came in with specific favors that we document in our report that they got from Donald Trump. I beseech my colleagues, I will read any book, any magazine, any speech you've given that you want me to read. Read this report and come back and tell me if you think Donald Trump did the right thing in converting the White House into a for-profit operation. No other president in American history has come anywhere close. And you ask why he's so determined to stay in office that he would unleash violence against his own vice president, the brother of your colleague, of our colleague. Why would he do that? It's because it was a money-making operation, and it was a great business grift for a guy who went bankrupt several times. And yet, out of some misguided partisan loyalty, you're going to stick with him. I don't even know why you stick with him. He was a Democrat longer than he was a Republican. He wanted to run for president on the Reform Party. You guys have been taken over by an absolute con man. And now you're acting like members of a religious cult who don't even remember how you got in the first place. We say return the profits, Donald Trump, $7.8 million. I've got a letter, Mr. Chairman, I'm going to share with you, telling Donald Trump to return these $7.8 million. It's a small fraction of what he raked in. We want to know about the other 2 years in office. We want to know about the other businesses, not just those 4 that we were able to get information on. And we want to know about every country on earth, not just the 20 autocracies and dictatorships that we found. This is our government. This is our Constitution. And we're going to stand up for it against Donald Trump and anybody who follows him to the path of oblivion. Abraham Lincoln started your party as a third party to replace the Whigs because they wouldn't take a moral stand against slavery. It was a pro-freedom, anti-slavery, pro-union, pro-honesty party. And your party has been reduced to a corrupt, authoritarian cult of personality. And everybody does whatever Donald Trump tells them to do, which is what we're doing here today with this stupid attempt to hold Hunter Biden in contempt when he has come forward to say he will testify and give you everything you want, as the chairman of the committee repeatedly offered in public. So forgive my outrage and indignation, but enough is enough. Let's get back to the business of the people, as Ms.
Chair
Brown
recognizes
said.
Mr. Higgins for 5 minutes.
Thank you, Mr. Chairman.
Thank you. Mr. Raskin?
Thank you kindly, Mr. Chairman. And I was glad that my colleague, Mr. Goldman from New York, was able to answer some of the surprising things that we heard from our esteemed colleague, Ms. Mace, right before we had our break. You know, it's very clear that Joe Biden is, there's no evidence that has turned up over the last 7 months that Joe Biden is guilty of any criminal wrongdoing, any high crime and misdemeanor, much less prostitution, bribery, money laundering, or any of the crimes that were set forth in that laundry list that that Ms. Mace offered at the end. So I do hope she will clarify that. Let's see. Ms. Wayne, you're here as the Assistant General Counsel of Johnson & Johnson. Do I have that right?
Yes, sir.
And Johnson & Johnson paid $5 billion out in the opioid litigation and $4 billion in the talcum powder litigation. Is that right? Those numbers roughly correct?
Congressman, as far as I'm aware.
Okay. So are you here to complain about meritorious lawsuits being brought by consumers in cases like these, or frivolous and meritless cases being brought by consumers?
Congressman, an excellent point. We're not here to talk about limiting aggrieved consumers' access to justice. We're here to talk about transparency, regulation, disclosure around third-party litigation funding, which has an effect of actually diluting the claims that have merit with the influx of meritless lawsuits.
Okay, so you have no problem with the litigants who went to court in the opioid cases or in other mass toxic tort cases, the BP oil spill or the talcum powder case or so on?
Congressman, as a lawyer,
Yeah.
I believe in access to justice.
Gotcha. And there were no Rule 11 sanctions that your company sought against any of the litigants in those cases, right?
The ones that you mentioned, Congressman?
Yes.
Not as far as I'm aware. In the
Okay.
mass tort context, it's actually extremely different. Because we have no access to information regarding the thousands of claims brought against us, because plaintiffs aren't required to actually produce evidence of product usage or injury alleged from the product, we're essentially hamstrung from using Rule 11 to bring sanctions on those individual cases. We're also hamstrung in many cases from filing 12b6 motions because that motion practice is usually suspended in the MDL process.
So you're saying you can't move to dismiss in a class action lawsuit?
Not a class action, Congressman, right? We're talking about multi-district litigation, which is a different animal.
Yeah.
Multi-district litigation, the aggregation of thousands of claims. Typically what we see are judges suspending motion practice, 12B, 12E, the usual discovery practices.
Yeah. Okay, well, that might be something interesting to look at, but to my understanding, anybody who brings vexatious, frivolous, or meritless litigation can be sanctioned by the courts. And, but I appreciate your candor in saying that that was not the case in the opioid litigation or in the talcum powder case.
What I said, Congressman, is that we believe in access to justice. So
Yeah.
those who brought those cases had their day in court. We don't stand in the way of that, of course.
Right.
And as I mentioned earlier, we don't believe that the talcum powder cases have merit. We believe that that is actually all driven by third-party litigation funding.
All right, fair enough. Well, maybe we should stop there because we're just going to disagree about that. And obviously, the settlement speaks for itself. One of our colleagues, actually several of our colleagues raised this issue, but one of them asked whether the Chinese government might have used intellectual property law or lawyers to achieve power over the U.S. government and to undermine American society. And I think I found at least one good answer to this question. And I'd like to submit for the record this November 6, 2018 Associated Press article headlined, "China Grants 18 Trademarks in 2 Months to Donald Trump and Daughter." In the early days of the Trump administration, Donald Trump and his daughter Ivanka got 18 trademarks from the Chinese government that she had been unable to get before, and there were lots of allegations about conflict of interest and influence peddling in the scheme. So I'd like to submit that for the record, Mr. Chairman.
Very good. Very good.
Yeah, I yield back. Thank you.
Thank you. Mr. Gosar.
Representative questioners, Ms. Mace, did you have any final thoughts you wanted to conclude with?
Thank you, Mr. Chairman. I want to thank our witnesses once again for their time today. And in hearing our witnesses this afternoon and this morning, I think the idea of censorship is a far more important issue than the issue of state superintendents of education, state boards of education, local county boards of education, and parents doing what is legally and rightfully theirs to determine is how their kids are educated in their communities. So when you look at this issue and you look at some of the censorship that's happening on college campuses, as we heard today from Dr. Pedlushny, I said it's very difficult to say your name, but thank you for being here today. But that kind of censorship on social media, that is far more dangerous than what we're hearing, I think, from our witnesses today. And I've experienced it myself. You know, part of the American experiment is being able to have a debate of ideas, to have this exchange of ideas and not get attacked for it. But we're seeing conservatives and some on the far left and far right being attacked every single day in this country. And the censorship and this erasure is not being applied equally. I know that Kremlin is tweeting on Twitter right now. We're banning conservatives from Twitter, and yet the Kremlin can still tweet today. And if you're going to have a standard, apply it equally across all users on social media. And complaining that parents go to school boards to have their voices heard is wrong. Accusing schools and saying that there's no safe place to go read in the classroom or the library. That should be the safest place to read. And so this is, I think, not an accurate representation of what's truly going on. But at the same time, we want to have folks like Ruby Bridges having her voices heard. There are so many Black voices, so many LGBTQ voices, too, that have the right to be heard at the same time. But the questioning of speech and looking at that from that perspective, even Bernie Sanders, I read a story earlier today from Daniel Moran's on Huffington Post, who's sitting in the room today, quoted Bernie Sanders not too long ago, that people have a right to give their 2 cents worth, give a speech without fear of violence, intimidation, etc. And yet today we have that going on. We had the end of a 2020 election where mainstream media wouldn't talk about the business that Hunter Biden was doing, wouldn't talk about the emails that were on his laptop, and wouldn't talk about some of the I would say allegedly shady work that he was doing, and whether or not his father was a part of that, and doing it at the tail end of an election. And so we see that every day. There was some citation earlier about kids not feeling safe because of their LGBTQ status. Mental health and mental issues are up. Depression and anxiety has been up by 25% over the last 2 years because of COVID-19. That is a statistic from the World Health Organization. I've seen it in my own family with my own children who have suffered because they were not in school. They were in virtual school. And I've seen some children that haven't been able to get it back. I've seen increase in drug use from kids who don't even have the ability to drive right now. And so when we're having these conversations about anxiety and depression of our students, I hope that we can have a broader discussion of how keeping our kids out of schools has actually harmed them over the last 2 years. And I just want to lastly say it again, Mr. Raskin, even though we sometimes disagree, we always agree to disagree, and I love the debate that we have in the Civil Rights Subcommittee on Oversight, and I want to thank you all for your time and being here today. Thank you.
Well, thank you for
And
that.
I yield back.
Thank you so much for that excellent conclusion and for making sure you'd be here with us today to participate in this. And I've got a few closing thoughts of my own. First, I want to thank our extraordinary witnesses, beginning with the students who were with us on the first panel. But I want to thank Samantha Hall, who's a librarian from the great Lancaster County in Pennsylvania, Mindy Freeman, who's a parent from Bucks County, PA, and we thank you so much for being with us along with your daughter. And Dr. Jonathan Podluzny, who's with the American Council of Trustees and Alumni, and Jessica Berg, who's a teacher in neighboring Loudoun County, Virginia. I also was very moved by the testimony and the seriousness with which all of you have approached a really important topic. And I just had a few cleanup thoughts I wanted to advance before we close. One is on the question of the fine old lost art of American heckling. I got heckled yesterday by our colleague Marjorie Taylor Greene on the floor of the House. And it was totally fine with me. I think they were about to gavel her down or tell her she'd be removed. It was, she was yelling at me, but she left some oxygen and space for me to respond. And I did. And that kind of heckling, if you go back and read the Lincoln-Douglas debates, there's a great compendium of the Lincoln-Douglas debates by an historian named Harold Holzer. But he includes the heckling that took place, and people would yell things out, and then Lincoln and Douglas would respond to them, and sometimes it would launch a whole new, discussion between the two of them. That kind of heckling is fine for me. The kind that I think we saw in one of the tapes where people are actually trying to shut people up and shut down the event, that strikes me as not within the spirit of the First Amendment, much less something like we saw on January 6th, which was the ultimate act of censorship. The ultimate expression of cancel culture was what took place on January 6th, where 900 people entered this building unlawfully, evading the metal detectors, evading the officers, actually wounding and injuring 160 of our officers, smashing them in the face with baseball bats and American flags and Confederate battle flags and so on. That, to me, was the essence of cancel culture. They were trying to cancel out our whole democracy on that day. They were trying to cancel out the whole Constitution. So I was not happy to see the relatively trivial violence before on the video at all. I don't think anybody was, wounded or given post-traumatic stress syndrome or killed in that kind of violence, but I wasn't happy to see it. And I'm not happy to see a form of heckling which is really just shutting down other people's ability to speak. The second thing I want to say, and we were about to get through the hearing so well on a great bipartisan commitment to the First Amendment, but I did want to respond to my friend Jim Jordan. I don't know if he's still out there somewhere. I'm sorry that he left the room, but it's very easy to feel that your group is somehow being unfairly targeted and made a victim. And I've spoken before to the distinguished gentleman from Ohio about this. He seems to believe that conservatives are somehow uniquely the victims of what he calls cancel culture. We've already heard from some people today, students, teacher, librarian, mom, about the actual attempts to strip books from people's libraries, and we heard from the great Ruby Bridges about the extraordinary and shocking effort to censor her books and remove them from public libraries in an attempt to silence the critical experience, the formative experience for our lives of the civil rights movement, affecting everybody, not just the African American community, not just the Latino community, the Asian American community, but the people in the white community, people all across the board. This is the American story. And so I guess what I'd like to say is I think that we're going to advance the First Amendment values that all of us hold dear if we can step a little bit beyond our own sense of grievance and indignation that somehow we are the first people ever to feel the sting of being marginalized. I know that conservatives feel marginalized. I think Oberlin is sometimes mentioned as a school, just like conservatives feel, liberals feel marginalized sometimes at George Mason University, or conservatives can feel marginalized at Wesleyan perhaps, and liberals can feel marginalized at the University of Chicago, okay? So let's try to maintain a sense of balance about that, and we can talk about how to improve the climate for everybody. I think it's within the spirit of First Amendment values that we want to give everybody the right to speak and to participate and to try to respect them as much as possible, as Ms. Berg said. And finally, as to the point raised by my friend, Ms. Mace, and I think a couple of the other members raised this too, we do have a kind of attention or a balance in our public schools, and by the way, our public universities too, between individual freedom and democracy. There is no doubt that we have democratic mechanisms like school boards and state legislatures and county education superintendents who are involved in the preparation of curriculum. That is a function of democracy. And at the same time, under our First Amendment, the Supreme Court has said, and certainly the people feel, our students, our teachers, don't shed their First Amendment rights at the schoolhouse gate. And so we have to try to reconcile those two values. All I would say about the current attempt to demonize and vilify people on school boards, teachers, librarians, is they are the democratic culture along with our PTAs and our parents. They are the people that have been put in by the voters all across America. They're doing a hell of a job, I think. And so just because someone decides that they want to go on a book-banning rampage or expedition doesn't mean suddenly that everybody who's been elected to the school boards or everybody who's in office or everybody who's head of the PTA is somehow the enemy of the people. I don't accept that. I think that the teachers, the librarians, the PTA people, the school officials are doing their very best to reconcile all of these values in a democratic society. And the First Amendment is there to protect all of us. And the Supreme Court, I think, has been real clear about viewpoint discrimination, whether at the higher education level. Check out Board of Rectors versus University of Virginia, I think it's called, in the Rosenberger case, where, no, you can't discriminate against religious student groups that want to get money to publish their newspaper. They've got an equal right to the Republicans and the Democrats and the liberals and the conservatives. Just because you're a religious group that's publishing a newspaper doesn't mean you can be discriminated against. But the Supreme Court's also been equally clear in the K through 12 context, while curricular materials have to be age appropriate. You can't take books out of the library because somebody else doesn't like it. And I'll just end with that image I started with. The First Amendment, freedom of speech, it's like an apple. And everybody just wants to take one bite out of the apple. And if we let everybody take one bite of the apple, there's nothing left to it. So we've got to defend not just the speech we love and the speech we agree with, but also the speech that might force us to learn something new, or the speech that we think we really detest and we despise. That's what the First Amendment is about. I want to thank the great Ruby Bridges for gracing us today. It means so much to us to have had you with us. And Ms. Hull, Ms. Friedman, Mr. Ludsny, forgive me, and Ms. Berg, all the students, everybody participating, thank you for this important investment in American freedom. And the meeting's now adjourned. Witnesses will have 5 days to get us any changes to their testimony, and members will have 5 days within which to submit additional written questions for the witnesses to the chair, and we'll send them to you if people have further questions, and please respond.